Hello, everyone. Welcome to Taking Technologies to Market, where we help businesses find and use the intellectual property and research that's going on in the state of Maryland. This meetup group, Taking Technologies to Market, is sponsored by the Center for Innovation, Technology, and Entrepreneurship, which provides evidence-based programs and training for economic development organizations and for businesses and entrepreneurs. The program is also part of the Maryland Defense Technology Commercialization Center, which is a program of the Maryland Department of Commerce funded by Economic Development Administration funds. And we work with the Maryland Federal Labs, or the DoD labs, and bring the technology and the resources that are going on within the labs out to business. We help businesses connect with labs so that they can make use of that research and help their business grow. So if I could remind everyone to just keep your mics muted if you're not speaking, and if you have questions or need anything, go ahead and put that in the chat window and we will come to that. So most of you know, we did several weeks ago, we had an event on reading and understanding a patent. We covered an awful lot of information. It was a high-level overview of how to read a patent, so we got a general look at that. We've had some questions, and we wanted to provide kind of a deeper dive. So we're going to go over in detail how to read a patent, and the patent that we're going to use two different patents, but the first patent we selected, both of these are available for license from the Army Research Lab. So if you happen to be interested in either one, please get in touch with us. So we're gonna go over first one that's fairly easy to understand. We wanted something that was somehow universally understandable, because not all patents are, and we didn't want to put you off with information that was too deep, too technically deep in one specific area, since we've got a broad audience. So with that, I am going to hand it over to Dr. Gary Evans. Gary Evans is the director of the executive director of the DefTech program. And Gary is also has run incubation programs. He's run technology parks. He's been deep in technology for a very long time. So Gary has read probably too many patents to count. So I'm going to share my screen, and I have Gary's slides. Okay, very good. I'm going to hand it over to you so you can take us through how to read and understand a patent.
I can certainly tell you how to read it. Understanding it may be a different thing. But before we get into that, just a couple of comments. First thing, really importantly, I'm not a patent attorney, so don't construe any of what we say as constituting legal advice. The intention isn't to give legal advice, but in any case, if you hear something that sounds like it, don't act on it. So what we want to do is talk about how you read a patent. So patents are inherently technical documents, and depending on the field that they cover, they can be very, very deep and require a lot of specialist knowledge to understand. We're not getting into that today. What we want to do is briefly touch on why you might want to read a patent and the kind of information that you can extract from a patent if you're familiar with how they're organized, and if you think carefully about how you can use some of the information that's in there. So there's lots of reasons actually why people might want to read a patent, and they're listed on the slide there. Technology awareness, if you're in business, you're developing something or you're selling products that have technical content, it's always a good idea just to maintain familiarity with what's going on in the relevant technical space. Patents can be very useful for market analysis. Again, if you're in an existing business, it's a very good way of finding out what your competitors are doing and what's happening generally within a given market. Another reason for looking at patents is the question of freedom to operate. This is a term that lawyers use a lot, and it basically means, is what you're doing infringing somebody else's patent? And you might not be infringing anybody's patent when you start doing what you do, but it's possible that a patent might be released that in some way may impact on that. And so it's important for that reason to think about what new patent literature is coming out and understand what's in it. If you think of filing your own patent, it's very useful to look at other existing patents in the field and look at the content, how it's structured, and think about how you might position your own filing in that context. Because one of the things that people don't realize is that whilst a patent is a very highly structured document, and a lot of that, or most of it, is defined in law, there's different approaches you can take when you're actually writing a patent with view to just how much information you include and what information you include. And it's useful to see what other people have done. The reasons most of the time, though, that people do actually look at patents are if they're looking for a solution to a specific technical challenge, and obviously understanding how to read a patent is important in that context. Well, they may be looking for a technology. They've identified a market opportunity, and they're looking for a technology that might give them some edge if they want to get into that market. There's probably other reasons as well, but these are probably the main reasons why people do read patents, or at least search for particular content, and there are good reasons for doing so. So if we go to the next slide, just a little bit of context. So patents are not a new thing. The first patent in England was granted, I think, in 1334. And the idea of what we think of as a patent probably goes back actually thousands of years. One of the key things you have to think about when you're looking at a patent is that it represents, in essence, a contract between the inventors and the state that allows the inventors to have a monopoly in the use of an invention. That monopoly is time limited, but in exchange for getting that monopoly, the requirement is that the inventors make the details of the invention publicly available. And they have to do it in a way which, in principle, would allow anybody who is familiar with the broad technical area that it's covering to be able to replicate what's in there. And that's one of the things that is examined and tested when you actually make a patent filing. Just for general interest, the word patent comes from a Latin phrase. I didn't study Latin at school, and so my pronunciation is probably a little off, but literae patentes, which actually means open letters, i.e. a public document. And so that's another point about patents. They are public documents. And this is true more or less worldwide. There's been a movement for many decades to harmonize all of the patent law around the world, and it's much, much closer now than it once was. But basically, there are some differences, but they're not usually significant. So what we're going to look at today should stand you in good stead for reading a patent that's been published anywhere in the world. As I said, the patent has to provide sufficient information for somebody to create for themselves what it describes. And so that sets a particular requirement for the content. The final thing that I'll mention is that the ownership of a patent can be transferred to somebody else. The terminology that's used for that is that the patent's assigned to somebody else. And that is something which is often evident in the patent itself. So you'll see there's a picture of a patent there. I am not going to ask you to read it. I particularly don't want you to try and read it, certainly not while we're in this session. You'll be able to get a copy of the patent if you are interested from the United States Trademark and Patent Office. What we're interested in is the structure of the thing, what information's there, and what we can learn from that. Basically, there are 7 sections to a patent. I'm not going to list them, read through the list now, but we'll just briefly work through all of those. We're actually going to spend most of our time now on the front page and on the claims. So if we could go to the next slide. So this is the front page. You'll see that there's a diagram at the bottom. There's a lot of text there. There's a diagram at the bottom. And the diagram is a representation of part or the whole of the invention that's being claimed. There are other diagrams that are usually provided, and we'll look at those at the moment. But most of what we're interested in here is the text. So if we could go to the next slide, Kim. So on the left there, same page, front page of the patent. And what I've done is I've taken the left-hand column of text and I've just expanded it. It may be a little small on your screen, but I'm going to talk through it. And as I say, if you would like to do so, we can make a copy of the slides available after the session if you'd like to have them as a source of reference. So let's just start looking at the specific information. So one thing that's at the top there is the principal inventor, somebody called Wetzel. That in itself doesn't tell you a huge amount, but further down, there's more detail on the inventors, which we'll come to in a minute. The next section, which is at the top of the patent there, is the title. And in this case, it says rate responsive stretchable devices. Depending on how the patent was written, that may not actually tell you very much. If you come to the patent with a particular object in mind, it might be relevant, but usually it doesn't give you a whole lot of information. We can get more as we go through. Next item there is that the applicant, the organization that was filing the patent originally was or is the US Army Research Laboratory in Adelphi, Maryland. So that can actually give you quite a surprising amount of information if you think about it in the context of that list I gave at the beginning, different reasons for wanting to read a patent. So what does it tell you? Well, one thing it tells you is that the US Army is interested in this particular area. And more specifically, it tells you that there's an Army research lab in Maryland, and it gives you the location, that is doing some work that led to the creation of this invention. And so you might want to look at other patents that the Army Research Lab have done and see if there's others in the same general field. You might want to reach out to the Army Tech Transfer Office and say, I'd be really interested to learn some more about this particular patent. In the same way, if you go down to the next little chunk that I outlined in red there, it does actually tell you the names of the inventors. By law, anybody who contributed to the invention has to be listed as an inventor, even if their contribution was relatively small. And nobody who was not an inventor can be listed. So in this case, we see that there were two inventors. One of them lives in Baltimore, one lives in Pennsylvania. The way the Patent Office views the world is that they're more interested in the inventors than they are the organization that they work for. Because in law, the patent is owned by the inventors. Now, if you work for a big company or if you work for the federal government, you may be required to sign a document that says you will assign any inventions that you create through their employment to that organization, which is perfectly legal. But in essence, the inventor is the initial owner of the patent. So one thing you could do is you could say, so this is kind of interesting. I'd like to know more about what work these two people do. And so you could take their names, you could do a search for more patents that they may have filed. You could look at scientific publications that they've authored or conference presentations. And these days, more and more of that kind of information is available online. And so you can actually build up quite a good sense of how much work is being done in this field by those people. You know, is it a major part of their work? Does it look like a major part of what the Army is doing in this space. And that can be very informative, not only if you're thinking about establishing a relationship with the Army to pursue something to do with this patent, but just for this broader understanding of what's happening in this particular technical domain. Now you'll see in the next highlighted block that it says the assignee is the United States of America, as represented by the Secretary of the Army. So it's a requirement that the inventors assign this invention to the government, but they are still the inventors. They're assigning effectively the rights to their invention to the government, but they will always be the inventors of this particular technology that's the subject of the filing. Now you'll see below that there's another highlighted block that says, subject to any disclaimer, the term of this patent is extended or adjusted under a particular part of the US Code by 175 days. So patents essentially run for 20 years. There are some circumstances where that can be extended, and one of those circumstances is if the Patent Office itself takes an undue amount of time to examine the patent and approve it or decline it. And you often see, particularly these days, you often see in patents that there's a note just like that that says the term of the patent's been extended. It's not usually by more than a few months, but that's what that's there for. So although I didn't highlight it, below that notice, you can actually get the number of the patent application on which this was based. You can actually get a copy of that. There's not necessarily a lot of reason to do that under normal circumstances, which is why I didn't highlight it. Now, the next section is really interesting. It says file June 26, 2013. So here we are, we're in 2020. What this says is it's approximately 7 years now since this patent was filed. So if you're looking at this from a point of view of competitive intelligence, or maybe even with the idea of licensing it, what you have to think of is, okay, so a patent has a 20-year term. This is already 7 years into that term. Two things: if I wanted to license it, what kind of terms would I look for on something that's already probably, I'm trying to do the math, 35% more or less of the way through its life. But also what you can deduce from that is that if this is a subject of real interest in the particular technical field that it's in, then there may have been a lot of other things that have been happening in the field since this was filed. So this may not represent the current state of the art. It probably represents the state of the art at the time that it was filed, but it may no longer represent that. But what you can do is you can look at the patent number, which is at the top there, and you can search for other patents that have cited this one. So if you want to get a forward look into this field about what happened in the intervening 7 years, this actually gives you a foothold into that. And through the USPTO, you can actually do searches and look for other patents that have referenced this one in some form. So again, in itself, it may not be the state of the art, but it gives you access to find out not only what the current state of the art is, but how interested other people were in it. So you will find some patents get cited by lots and lots of people. And that probably means that whatever the content of the patent is, it's something that was significant in that particular field. If not many people have referenced it, it doesn't necessarily mean that it's not important, but it means that other people didn't think that it was important enough to reference it in their own work. And referencing it could be in the form of another patent, or it could even be referenced in an academic publication as well. So the next chunk, which is highlighted, is related US application data. So you can see there that a provisional patent application was filed on July the 11th, 2012. And so that date, when you file a provisional application, that date is taken like a flag or a stake in the ground that says, that's the date from which I am claiming the contents of this patent. Anything that happened before that, you can't say you invented. And what it does, though, is gives you that stake in the ground, particularly if you think this is a rapidly developing field and you want to put a marker down. It's worth doing that. We won't get into the ins and outs of provisional patent applications now, but what that tells you is actually the content of, or at least some of the content of the patent was complete in 2012. So even though this was granted in 2016, some of it goes back even further. And even though it was actually filed in 2013, some of the content goes back earlier than that. And so again, what that tells you is just sort of contextual information about how relevant is this likely to be to the current state of the art in that particular domain. So let's move on. The final chunk there is really, really useful, although it's very difficult to make sense of if you're not familiar with it. There is a system of classifying the technical subject area of patents, which are referred to as CPC codes. And you'll see in the middle of that block, it says USCL section 52, and then it says CPC, and gives a list of strings of numbers. What those numbers represent are specific technical domains. I won't get into this in detail, but if you have sufficient reason to do so, you can dig into that. You can say, okay, I want to find other patents that cover this same technical area, even if their title doesn't make that obvious, even if it's by a different inventor, you can actually look into that. And so this one patent can give you a window into an entire technical domain. CPC codes are actually not that difficult to understand if you have a technical background, but it's pretty dense. There are literally tens of thousands of them. And although it's very structured, it's not for the faint of heart. But the CPC code can be really useful, again, for using this as an entry point, finding out what other work has been done in the field, and what other people are working, where they're working, who they're working for. And you can build quite a detailed picture of that whole technical area just using this one patent as a starting point. So if we skip on to the next slide. So what I've done here is a similar thing. This is just the right-hand column of the page highlighted. I highlighted the date of the patent again. That chunk that's highlighted in yellow, or bordered in yellow, gives you the references cited in the patent. So when you file a patent application, you have a legal obligation to disclose any information that is relevant to your application. And that's generally referred to as prior art. If you don't refer to other patents, particularly, or other work, could be scientific publications, if you don't refer to those and they contain information that could be considered by the patent examiner to invalidate your claims, then it's quite likely that the examiner may do that. And so it's in your interest to make a reasonable effort to identify other work that's been done which is similar. And what you do then is you highlight how what you do is different. So the fact that somebody has done something similar doesn't mean you can't patent your thing. What you're actually doing is saying, yeah, these other people did something that looks similar to this, but what we have is different, and this is how it's different. And so citing other patents in particular is really important. However, you'll see that by a couple, if you look very closely, you'll see that by a couple of those other US patent documents that have been referenced, there's a tiny little asterisk. What that means is that the patent examiner added those. So when your patent goes to the patent office, a real person sits down and reads it, and it's somebody who has a relevant technical background. They will read the content, they'll understand it, they'll evaluate it. They will do their own search for other relevant information. And if they find something that they think is relevant, they'll add it. And that's what those little asterisks mean there. It's not necessarily a bad thing. And it's generally the case that a patent examiner will find other material that you weren't aware of. But if the patent examiner finds a lot that you haven't referenced, that may not be seen in a positive light. But obviously, this patent was granted. It's been issued. You see below that, it says other publications. That basically means anything that's not a patent. And so you'll see there, they reference a couple of scientific papers which they think contain material that's relevant. And again, that's under the context of it's something where you're trying to distinguish and differentiate what you've done from what they've done. So that gives you another window into this technical domain. Even though those people aren't inventors on this patent, they work in different places for different organizations. They obviously were doing something that's relevant to this particular topic. And so you can pursue those, and you can do the same thing. You can look at other publications they've created, and you can build up quite a detailed picture of this particular technical domain just by following up this information that's there on the front page of the patent. So we're going to move more quickly through most of the remaining material. The area that's in green there is the abstract. That's basically a very brief summary of the invention. It can be somewhat informative, and it gives you a sense of what the subject matter is, but it's relatively limited. You'll see down at the bottom there, there's a sort of purple, an area with a purple border, and that's also extremely interesting. 25 claims and 9 drawings, and we'll come on to those in a minute. So for the sake of completeness, what I would like to do is, Tim, if you would just skip to the next page. So there you go. That's just the total of those different areas that I highlighted. If we could go on to the next one after that. So second section in the patent is drawings. Now again, not going to get into the interpretation of these charts that they've included. They included pages, several pages of other diagrams. The reason I'm including this is because almost all patents include drawings, and the idea of the drawings is that they illustrate some material, some aspect of the invention that is being claimed, and with the idea not only of demonstrating to somebody else how this thing could be made or replicated, but demonstrating that what they're claiming does actually do something unique. In this case, what they're saying essentially is we have this stretchy thing, and if you stretch it gently, it's fairly easy to do. If you try and stretch it very quickly, kind of jerk it, it'll resist that movement. And that's the essence of the thing. These charts, at least in some form, provide some sort of experimental evidence that that's the case. Drawings in patents tend to be quite formal, and they follow a particular set of standards that are defined by the USPTO. They're not necessarily the kind of drawings you would see in other situations. This one does what it's supposed to do. It actually gives evidence that the thing does what they say it does, but it doesn't give you very much more than that. Some patents can have a lot of drawings, and if you're really interested in the technical area, you need to step through them and they'll give you a much more full understanding of the content. Okay, let's move on to the next slide. So back to blocks of text, I am afraid, but that's patents for you. So several chunks. You will see that the first area that I've highlighted says cross-reference to related applications. So it basically references the provisional filing which was made in 2012. We already spotted that and noted that, but this just confirms very clearly that this was based on a provisional filing. Second thing that I highlighted there is government interest. Because this work was funded by the federal government and undertaken by federal government employees, the government claims the right to use the invention and not to have to pay royalties for it. That sounds pretty drastic, but it's not really in practice. What it's really saying is the government doesn't want somebody else to make use of this patent and then charge the government for it. But it's worth looking out for that. It's just an additional piece of context. Then you get into the first real substance of the thing, which is the background of the invention. Unfortunately, this is still deliberately a kind of summary. It talks about the technical field in a broad way, and then it talks about the related art. So this is putting your invention or the invention that's covered by the patent in context. That is enough usually to give you some sense of, might I be interested in this particular patent or not? But actually, it's the next section, which is on the next slide, where you're really starting to get into a meaningful, if you like, or detailed description of what the invention actually is. The summary of the invention is usually not very long. You see, I highlighted the part of the patent in red there that covers the summary. That is really where you find the substance of what the invention is, why the inventors thought it was important, and how it's different from what's been done before. So if you come to a patent completely cold and you really want to go straight in and say, okay, really what is the essence of this invention, the summary is the place to start. It doesn't tell you all of the detail of the invention. That is covered in the next section. If you could go to the next slide, Kim. The brief description of the drawings of the, you've jumped ahead one there, that's okay. The brief description of the drawings, which is what it says, that can run to many pages. In this case, it's only one full column, but it can actually run much, much longer than that, because the drawings are supposed to help explain, along with this description, how you actually do the thing that's being claimed in the patent. And then after that, we get to the next section, next slide, which is the detailed description. Now, this is where you really start getting into the fine detail from a technical perspective. You look here, I put on the slide there are about 6.5 pages of this closely typed text, in this case, that cover the detailed description of the invention. That will be highly technical. And if you're not familiar with the technical field, it will become probably very quickly incomprehensible. But it's a necessary part of the patent, because this is really where what has been claimed in the patent is being described in detail, and the information is provided on how to actually replicate it. So this is another really important point. If you're looking at a patent and you're thinking about licensing it, one of the first things you have to do is see if you can replicate what's actually claimed in the patent. That's not to suggest that people who file patents are deliberately misleading, but it's not always the case that what's in the patent can be replicated for all kinds of reasons. But if you're planning to make use of that and actually incorporate it into some invention with an appropriate license, of course, it's really important to satisfy yourself that this really does work, or at least it works in any kind of context where you can actually try and make it work. So that's really, really important, but it is dense, and we're not going to go through that in detail now. So if we jump to the next section, please, next slide. This is after the information that's on the front page and the summary of the invention. This is really where one of the most interesting areas is. So you'll see, if you look very closely, top of column 14, it says, "We claim." And after that, there is a list, a numbered list of things that the inventors are claiming. Again, I'm not going to read through all of those because it's not really relevant in this context. What's important to understand is that the claims have a structure. And I put those numbered blocks to the right to illustrate that. So claim 1 is the principal claim. Everything after that, from claims 2 to 12, refer back to claim 1. Claim 13 refers back to claim 12. Claims 14 and 15 refer back to claim 1. I won't talk through the whole thing, but if you think about it, the structure is actually quite logical. But why this is important is if you file an application and the patent examiner says, "I don't buy this, I'm not going to allow claim 1, all of the things that derive from claim 1 are also disallowed. And so people put a lot of thought into how they structure the claims when they're writing a patent. The examiner might say, "I don't buy claim 19, sorry, I'm disallowing that." That leaves all the claims from 1 through 18 in place. What that also means is in a situation where there's a legal case where somebody's challenging a patent, or somebody's claiming that maybe you've infringed their patent, which specific claims are being infringed is really important, because a court may say, "Yeah, we agree, you're infringing claim 19 of this patent." We say, "Okay, I'm only infringing that one claim. Maybe there's a way I can re-engineer what I'm doing that will avoid that, and maybe I can still, work around the other claims as well." What you'll see is that claims 22, 3, 4, and 5 are on the same level as claim 1, so they have the same standing, if you like. So claim 1 could be struck down completely, and those 4 at the end would still stand. Claim 23 could be struck down, and everything else would still stand. So understanding the structure of the claims is really important, because it gives you insight into what the inventors were thinking about when they wrote the patent, and what insight that can give you to the relevant importance of different aspects of the invention. So a lot of the claims will often say, "We're also claiming the same thing that we claimed above, but we're doing it with a different material," or "We're using a solution that was a different concentration," or "We're putting it in a different shaped box." And so those things are kind of peripheral. The high-level claims, in this case, it's claim 1 and 22 through 25. Those are the ones that are, in a sense, the most substantive ones that you want to focus on. And you really need to read those in detail and understand them in detail if you're actually going to go ahead and try and license the patent or use it in some other way. It's less important if you're using this for some of the situations that I referred to in the first slide, which is, if it's for general market information, if it's for looking at what a competitor is doing in a broad way, probably less critical. The earlier information is probably more useful, and certainly takes less time to examine than this. But at the heart of it, the claims are the key thing that the patent is covering. Those are the things the government is giving the inventors the monopoly for. And so they are a fundamental part of the thing and worth understanding if you have the level of interest and the time to do so. So just very quickly jump forward one more slide. Just a couple more points I want to make. So these two sides of the slide probably look the same, but they're not. The one on the right-hand side, if you were to look very closely, has the date of May the 1st, 2018. The one on the left is the one that we've just been looking at by the same inventors. And I highlighted some of the same areas on each side. So what's the deal with this? Well, what it is patent law allows you to essentially extend the content of a patent. Say you file a patent and it's granted, or even while it's being processed, you find some new results or discover some new aspect of the thing. What you can do is actually file what's called a continuation. And that basically lets you, for want of a better way of putting it, and I'm sure a patent attorney would not like this language, it allows you to update the patent. You don't get additional years added to the life of the patent, but it allows you to add additional material. So in this case, they found some additional things. They filed a continuation a couple of years after the first patent was granted. This one was granted. And that means this was important enough for them to think that it was worth doing that. There's a cost to filing patents and maintaining them. It's not a kind of no-brainer to file a continuation. But it says it attaches something to the patent, which means that it was important enough for them to do that. So again, if you're looking at what's important in this domain, if you're looking at how interested people are in it, then that gives you an additional signal. There may be additional references that are cited as well, which again give you an opportunity to do further exploration of the field. We won't dig into the differences between the two, far too long-winded to do that, but I wanted to highlight to you that you will not frequently see that, but it certainly occurs that you'll see what looks like a very similar patent with a later date. It's a continuation that's being filed. So next slide. This is the second patent. We are not going to dig into this in detail. I want to highlight two things about it though. Firstly, I haven't done it, but if you were to do the same highlighting, you would find that the front page of this patent is identical in structure to the other one, because that's defined in law. In this case, different diagram. What this is for monitoring the condition of platinum membranes, which are a big deal in hydrogen fuel cells. And so if you're in the hydrogen fuel cell business, or you're thinking about being in the business, this patent would probably be important to you, because what it talks about is a way of monitoring the condition of the membrane, which is a key part of the fuel cell. And so this is something you probably want to know about. But the reason why I wanted to highlight this one is, if you could go to the next slide, Kim. Drawings. This one has a lot of drawings in it, and they provide a lot of detail on how the experimental equipment was constructed, the relative proportions, how it was designed. And if I'm looking at a patent and I'm thinking, can I replicate this? I'm really interested in this. I want to rerun these experiments in my own lab and see if I get the same results. This patent actually gives a much, much better explanation of how you would do that than the first one does. I love all the detail in these drawings, and there's pages of them. So if I were looking at this, I think this is great. I can really, if I'm interested enough, if it's important enough, I can really try and replicate this. And I can do that legally, as long as I'm not selling it to anybody. There's nothing to stop me repeating exactly what they've done and seeing if I get the same results or maybe different results. So looking for high quality drawings is really important in my experience. I've run companies and run R&D operations that do this kind of thing or rely on this kind of thing. And so that is really important. Second point that I wanted to highlight on next slide is data. So it's up to the inventors how much data they put into a patent. Again, it has to be sufficient to convince the examiner that the patent is worth granting. The earlier patent we looked at just had those two charts in, which were actual experimental results. And they told you a certain amount, but not a whole amount. This patent has lots of data in. And this is standard measurements that most technical labs could easily replicate. It's very specific, and the text that supports the diagrams explains what was done in great detail. And it really does give you the information where you can say, okay, I've repeated what they say they did. I've built exactly the same device. I've done the same things with it. Do I get exactly the same results? And so for me, particularly if I'm thinking about licensing a patent, that is really important because I want as much information as possible. Now, of course, you can always go to the inventors, in this case through the Army Research Lab, and talk to them directly, but depending on where you're located and what your resources are, that may not be practical. Having all of the information you need in the patent to really validate it is really important. And this one does, in my opinion, a very, very, very good job of it, more so than the earlier one. So that was the final slide. Hopefully we managed to keep the momentum up with that. And I just want to quickly repeat what I said earlier on at the beginning. There's lots of reasons to read a patent. When you get used to looking at them, it's really not very difficult. There's lots of information in there if you dig into it and you understand it, and it can be really useful in a lot of different business contexts. Final thing then, I would say, if you're in the business of using technology in your products or services, you really should be monitoring the patent literature, not just in this country, but in other countries as well, to find out what other people are doing. They may be doing things that are going to harm your business. They may be doing things that would make them good partners, or they may just be doing stuff that makes you think we're still ahead of the game. It's a really important thing for you to do if you're in a technically driven business. So with that, I will finish, and I'll hand back to Kim.
Okay, thank you for that, Gary. We've been putting a few links and pieces of information in the chat so that, if you're interested in, Gary mentioned being able to replicate what's in the patent. And we put a link to a prior video that we did, or a prior event that we did, where we talked to RPM Tech Cyrus, and Cyrus explained to us how he can help businesses replicate a patent and develop a prototype. And we spent quite a bit of time on that. I'm wondering if anybody has any questions. We didn't pause for questions while Gary was talking. I'm also interested in hearing what you thought was most interesting about that. What was a new thing that you learned, or something you didn't know? And that's just, for our own interest, really. So I'm gonna pause for just a second to see if anyone has any questions. Okay, so we did put links to our LinkedIn profiles in the chat. We put a link to the DefTech website. I did add a comment that just to remind everyone that DefTech exists to help businesses connect with the resources that are in the federal labs. That's the inventions and the patents that are available for license. We can help you connect to the researchers. If you're interested in a patent, we help you connect with them so you can get more detailed information and ask technical questions prior to licensing. They also have facilities available. They have testing available. So there's a lot of ways business can use those resources to help their businesses grow and strengthen their businesses, and sometimes to also spin any new technology back into the Department of Defense to support their mission needs. 2 weeks ago, we had an event that we are doing with our partners at the Maryland Innovation Center, which is located in Howard County. And they have done all the hard work of finding an absolutely wonderful speaker to teach us about market research. We harp on that. We, meaning DefTech, really harp on that. We want you to understand the customers that you're working with and understand them very well before you spend money on licensing something or building your business further even. So this is a 3-part series that the Maryland Innovation Center put together, and DefTech is co-hosting that. It's on market research. So part 2 is going to be on July 14th, and you'll see that on our Taking Technologies to Market meetup. So if that is all, then I will wish everyone a happy 4th of July. I hope you have a good rest of your day. And if you're dealing with end of fiscal year things, good luck. Relax on the 4th, the long weekend, and wash your hands, socially distance, and let's all respect each other. Thank you. Have a good rest of your week.